It, incidentally, for those who are watching and think that we may be polarized in things, I listened to what Senator Grassley said about cameras in the courtroom, and of course, I agree with him on that, and he knows I have supported that. I've also joined with him on a few of the False Claim Act improvements. So there are many areas in our committee where senators have worked together. And I would ask, Mr. Chairman, if I could, unanimous consent, that a letter from 10 former federal judges who are opposed to the process of this nomination, along with letters of opposition to the nomination from People for the American Way, NARAL, and 208 women lawyers, and that they be inserted in the record.
Without objection.
You have to assume somebody's going to hand you those letters. I can't quite reach from my room here. Now, Judge Barrett, it's good to see you again. I commend your children. I'm sure this is fascinating, but I'm sure it's a long day. And I'm sure you probably felt the same way, but this is part of democracy, and it's important that we have these questions. Now, we're being told that no one could possibly know how you would rule in the latest Republican-led case to overturn the Affordable Care Act. But what we do know is that you criticized Chief Justice Roberts' opinion in NFIB versus Sebelius. You stated that, quote, Roberts pushed the ACA beyond its plausible meaning to save the statute. And then you praised the dissent in King versus Burwell. So it seems every time you've weighed in on the legality of the statute, you come to one conclusion: the Affordable Care Act is unconstitutional. Now, over the past 2 weeks, you provided this committee, all of us, with some 1,800 pages of your writings and speeches for us to review, and I have. Now, I may have missed something in that, but did you ever write or speak out in defense of the ACA?
Senator Leahy, I just wanted to make one correction. King versus Burwell wasn't a case about whether the Affordable Care Act was constitutional or not. That one was purely a question of statutory interpretation. So just to make clear about that.
But I would say that the dissent. You did praise the dissent,
I
not
did.
the fighting.
I did. In a
Thank
radio
you.
interview, I said that I thought the dissent had the better of the statutory interpretation argument. I have a couple of things, I guess, that maybe might help shed some light on this question. One is that, of course, in both of those contexts, I was speaking as an academic. And as I mentioned yesterday, an academic serves a very different function than a judge. So an academic doesn't go through the judicial process, doesn't hear the case or controversy, have the litigants and the briefs and the consultation with colleagues, the writing
Judge,
of an opinion.
We all understand that, but that's not my question. My question was, did you ever write or speak out in defense of the ACA, whether as a academic or as a member of the judiciary? That's a pretty simple question.
No.
Could be answered yes or no.
No, I've never had occasion to speak
Thank
on
you.
the policy question.
And so every time you've weighed in on it, you said the law is unconstitutional. Now,
No. Sorry, I thought you were done.
well, and the court, of course, have to it's going to have to look at both severability, standing, constitutionality, and you haven't written on severability of the ACA, have you?
I have not.
Thank you. And now, here's a quote that I'm sure you're familiar with in preparing for this, and it's been used in the last few days. Quote is, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. Have you heard that quote before?
I believe that's from the dissent in Shelby County.
By Justice Ginsburg, is that correct?
I believe so.
Actually, it is. She was talking about and warning about striking down Section 5 of the Voting Rights Act. Now, Shelby County, it was almost like immediately after Shelby County came down, states started making changes. 20 states enacted new restrictions on voting. And some of those restrictions have been horrendous. Do you know how many polling places have arbitrarily been closed across the country since the Shelby decision?
I do not know, Senator Leahy.
I'll help you there. It's at least 1,600. Now, following the Shelby decision, do you know how many voters were purged from voting rolls?
I do not know.
Roughly 16 million. That's about 30 times the population of my state. African Americans with felonies are 4 times more likely to be disenfranchised than other Americans with felony convictions. Non-white voters are 7 times more likely to wait in line for more than an hour than, black voters wait longer in line than white voters. I mention this because this is a picture from DeKalb County, Georgia. Both of the lines, African Americans make up the majority. Look at that line. I suspect neither you nor I have ever had to wait in line like that to vote. In fact, the press reported that today those lines could be 10 hours long. People talked about, well, are we giving racial entitlement? This is not entitlement for any Americans. This is not entitlement. This is turning our back on democracy. This is saying you can't vote, or we're going to make it so difficult for you to vote, you can't. Harris County in Texas, which has population many times that of my state, has 1 early voting spot. People have to drive for hours and wait in line for hours to get there. Would you accept the fact, or would you acknowledge the fact that communities of color disproportionately face restrictions and obstacles when they are casting their ballots?
Senator, I wasn't aware of the statistics that you were citing to me. If it became relevant in any case that was litigated before me and was presented to me, I would, of course, have an open mind about it.
Well, I talk about this because I know you have spoken feeling much like former Justice Scalia, who I would note was a friend of mine. But I disagreed with him on many things. He talked about racial entitlement. It's not racial entitlement when blacks have to stand in line for 10 hours to vote. And Justice Ginsburg, of course, dissented in Shelby. She knew what the consequences would be. I only mention that because it's okay for a judge not to close his or her eyes to reality. Now, I asked you last week what a Justice Barrett would do if a president or even a senator did not follow a Supreme Court decision. You declined. You said the question may come before you. I then asked if the Supreme Court would have the final word. You stated the Supreme Court would have the final word as far as the lower courts are concerned. And that surprised me, and it concerned me, and I'll tell you why. I asked Justice Gorsuch and I asked Justice Kavanaugh those questions. I asked them what happens then, and they made it clear that a president cannot refuse to comply with a court order, and the Supreme Court's word is the final word on that matter. That's what Justice Gorsuch and Justice Kavanaugh said. So I would ask you this. Do you agree that a president must follow a court order and the Supreme Court's word is final? Or is the Supreme Court's word only final as far as the lower courts are concerned?
Senator Leahy, I'm glad to have the opportunity to clarify from our conversation. First, I know that both Justices Gorsuch and Kavanaugh said that no man is above the law, and I agree with that. But I conversed with Senator Lee yesterday about Federalist 78, which says that courts have neither force nor will. In other words, we can't do anything to enforce our own judgments. And so what I meant in the conversation with you is that as a matter of law, the Supreme Court may have the final word, but the Supreme Court lacks control over what happens after that. The Supreme Court and any federal court has no power, no force, and no will, so it relies on the other branches to react to its judgments accordingly.
I remember as a young law student having lunch. Our honor society at Georgetown was able to have lunch with the members of the Supreme Court. I sat with Justice Hugo Black. He told me what happened with Brown versus Board of Education. And the court knew that was going to be a very, very tough case. And what did they do? They waited till they had a unanimous opinion because they knew that the president would have to, and the Congress would have to enforce their law. So let me ask you this. Of course, the Supreme Court has no army. They have no force, but they do have the force of law. And is a president who refuses to comply with a court order a threat to our constitutional system of checks and balances?
Senator Leahy, I think the example of Brown is a perfect one in this instance because the Supreme Court in Brown, of course, held that segregation violated the Equal Protection Clause. That was the law, but as you know, there was resistance to that decision. And so it wasn't until the National Guard came in and forced Governor Falbus to allow desegregation that it could happen because the Supreme Court couldn't do so itself. And in Cooper versus...
I understand that, but they made the order. And could a president, if a president refused to follow what they had said, would that be a threat to our constitutional form of government?
Well, as I said, the Supreme Court can't control whether or not the president obeys. Abraham Lincoln once disobeyed an order during the Civil War of a circuit court. So a court can pronounce the law and issue a judgment, but it lacks control over how the political branches respond to it.
Well, then let me ask you a specific that has come up. President Trump claims he has a absolute right to pardon himself. Now, for 200 years, the Supreme Court has recognized the common law principle that nobody can be a judge in their own case. I had to go way back and reread Calder versus Bull to see that. But would you agree, first, that nobody is above the law? Not the president, not you, not me. Is that correct?
I agree, no one is above the law.
And does a president have an absolute right to pardon himself for a crime? I mean, we heard this question after President Nixon's impeachment.
Senator Leahy, so far as I know, that question has never been litigated. That question has never arisen. That question may or may not arise, but it's one that calls for legal analysis of what the scope of the pardon power is. So because it would be opining on an open question when I haven't gone through the judicial process to decide it, it's not one on which I can offer a view.
Okay, and so, but you were willing to say that no person, not you, not me, not a president, is above the law. I find your answers somewhat incompatible, but those are your answers. You have a right to say what you want. Now, you're an originalist. Can you explain why the framers include the foreign and domestic emoluments clause in the Constitution?
I think I could speak generally to what is the well-accepted view that the foreign emoluments clause, it's plain from that text, that it's designed to prevent foreign influence in government affairs.
It's sort of the anti-corruption clause of the Constitution, isn't it?
I'm sorry, could you repeat that question?
It is sort of what you would say that it's the anti-corruption clause in the Constitution.
I don't know if I would characterize it as an anti-corruption clause. I think I would characterize it just as I did, which one, from its very text, you can see is designed to prevent foreign countries from having influence.
I was thinking of what at the Constitutional Convention, Governor Edmund Randolph said the clause was thought proper in order to exclude corruption and foreign influence, prohibit anyone in office from receiving or holding any emoluments from foreign states. And now we find that 200 companies and foreign governments have patronized Trump properties. At the same time, they were getting benefits from him and the administration. First 2 years of his presidency, he earned $73 million from his properties abroad. And an originalist, as you are, do you think these companies and foreign governments would have fallen within the framers' zone of concern in writing the emolument clause?
Senator, the emoluments clause, it's under litigation. There was a Fourth Circuit case that recently involved this question. So as a matter that's being litigated, it's very clear that that would be one that I can't express an opinion on because it could come before me.
I've found it interesting what you've written about stare decisis and precedent, and it seems that you're willing to depart from it, and that's as a justice, I suppose you could do what you want, but in the June medical services, Chief Justice Roberts joined the majority, struck down a Louisiana law restricting access to reproductive services, even though he had dissented in a previous case, striking down a very similar Texas law. And he said the legal doctrine of stare decisis requires us, absent special circumstances, to treat cases alike. So having been on the losing side in the first one, he took that position of that case. Do you agree that he demonstrated a commitment to stare decisis in this case?
Well, Senator, no justice that I'm aware of throughout history has ever maintained the position that overruling a case is never appropriate. As you probably know, there's a Supreme Court case that said that states could criminalize sexual conduct between same-sex couples, and Lawrence versus Texas overruled that case. Plessy versus Ferguson was precedent, and Brown versus the Board of Education overruled it. So the Supreme Court has always said that in some cases, overruling precedent is the right course for the court to take, but that it's not done willy-nilly.
I would urge you to read what Chief Justice Roberts said at the opening of the African American Museum in the Smithsonian about following precedent. I realize my time is up. I'm going to I'll submit a question to you because I wonder what restrictions you see in the president's authority under Executive Order 12333 to conduct surveillance activities that haven't been authorized by Congress. I ask that because Senator Lee and I and others have done a lot of legislation on surveillance, and now we question whether that's being ignored. So I hope you will take it as a serious question and answer it for the committee.
Thank you,
Thank-
Senator Leahy.